An alternate dispute resolution is a process where you can appeal your spousal sponsorship refusal and have it dealt with quicker and less formal than a full appeal. What takes place during an alternate dispute resolution is you're in a room around a boardroom table with a hearings officer, a dispute resolution officer, and you should have your counsel. Prior to going to your ADR, you have to submit disclosure documents that should resolve any questions for the reason for refusal. For example, if you claimed in your forms you had 100 people attending your reception and you never submitted any photos showing these 100 people to the visa post, that could be one of a few other reasons, including a few other reasons why you got refused. What takes place in the alternate dispute resolution is you're being asked questions by the hearings officer. It is not the dispute resolution officer that makes the decision. It's the hearings officer. The hearings officer has to be satisfied that based on your answers and not the applicant's or answers, that your marriage is genuine, that it was not entered into to gain any benefit under the Act, for example, permanent residency status. When you answer questions about your partner, you should know and refer to your partner by name. Don't say he, she did this, he, she did that, he wants to do this, he wants to do that, etc. The problem is you need to refer to your partner by name, which you would normally do. You need to show that whatever answers your partners gave or whatever answers were on the forms, that the visa officer question can be easily explained. Once your answers are easily explained, you will be approved as an appellant because the hearings officer, and only the hearings officer that will be sitting directly across from you, is of the belief that if you went to a full appeal, you would be successful. You have to convince the hearings officer. You do not have to convince your counsel. You do not have to convince the dispute resolution officer. And your partner, the applicant overseas, will never be called to explain his or her answers. It is informal. It is normally for a Regulation 4 refusal, where the visa officer didn't believe on the evidence that you submitted that the marriage was genuine. It could have been rushed into too quickly. There could have been too much difference in age, too much difference in religion or education qualifications, etc. Certain things that needed to be explained were not explained. And your partner's answers did not always make sense. So, when you are appealing, make sure that you submit disclosure documents according to the Immigration Appeal Division rules. Hire a quality representative who can provide references to show that they have been successful at other spousal appeals with similar circumstances to yours. When you are represented by a quality representative, that person should put you through at least 3 mock interviews and be able to inform you of at least 80% of the questions that the hearings officer is going to address. Once you hire quality, your partner will be with you sooner than you expect. Wishing you all the best, and hopefully your partner will be here far sooner than you expect. Thank you. CVImmigration, Roy Kellogg.